From the WATE.com Digital Center, answering your legal questions, this is Ask Isaacs. Now, here's Lori Tucker and attorney Greg Isaacs.
And hello, everyone. Bo Williams here, filling in for Lori Tucker. Lori off this week, along with Greg Isaacs. Greg, great to see you.
Bo, good to see you.
We've got an interesting topic today. We're going to be talking about the Karen Read trial, really the second trial, and we will touch on the first trial as well. This is one that's been getting national attention for quite some time now. So many twists and turns in this one. But if you haven't been following along, first, Greg, I'm just going to ask you to kind of walk everybody through where we are right now, kind of how all of this started and how did we get to this point.
Fascinating case. I helped cover the first Karen Read trial on Court TV. Basically, Karen Read was dating a Boston police officer. They had been out at some local bars. Then the story kind of diverges. So apparently she was getting texts from another police officer. They went to the house of this other individual. An argument maybe happened between Karen Read and her boyfriend. She then leaves in the early morning hours. Her boyfriend does not come home. She calls his family. And she, along with two female relatives, go to look for him and find that he had been, whether you believe two stories.
Yeah.
Whether he had been hit by a car and was lying in the driveway dead, or whether he had been attacked inside the home beaten and then bitten by a dog and then placed in the driveway. Those two theories diverged, but there was the dead body of her boyfriend, and the story got more bizarre as the trial unfolded.
Yeah, and when you start looking at the prosecution and the defense on this one, and the two stories that they're trying to push forward, they are so polar opposite. I mean, so different. One, you've got them saying, she said, I hit him. But as we were talking before we went on, the question comes up, well, how did she say that? And then you have the other side saying, well, wait a minute, this looks more like a dog bite. He wasn't hit by a car.
It's one of these unique cases that have really, captured the nation. I was actually in another county talking to a judge in a homicide case, and we were in chambers, and wanted to know my thoughts on the Karen Read case.
Right.
He was, in fact, thought that she was not guilty. So, as we continue, you have the scene in the driveway where her boyfriend, the Boston police officer, was dead. EMTs show up. She allegedly said, I hit him. Now, you would think a lot of times that would be enough for some evidence. But then there's a debate on whether she was being rhetorical, like, did I hit him? Did I hit him? Was it said with inflection? So that really didn't faze jurors in the first trial when they were hung. Then you have a battle of the experts where the defense experts say that his injuries were not consistent with being struck by a vehicle. Conversely, the defense experts say the injuries are consistent with someone that was beaten in the home, brought outside, and attacked by a dog. So you have those two very divergent theories. Factor in the lead investigator, Trooper Proctor, had close ties to the individuals, which were law enforcement officers in the home. And the defense theory was that this was a cover-up, a conspiracy from the beginning. They do a deep dive on Trooper Proctor.
Right.
Lo and behold, he was a, quote, as they say in Boston, Massachusetts, a dirty cop. He gets fired almost immediately after the judge declared a mistrial in the first case. And fast forward.
Well, he was sending out some texts, right? He was in things
doing
like that.
A lot of stuff.
Karen Read.
He had trouble with, he was disparaging Karen Read. He was acting very inappropriate, very unprofessional for someone that is one of the lead prosecutors in a criminal case. But he was immediately terminated. So the judge declared a mistrial. So in the interim, and when cases get crazy and cases get snake bit, things continue to happen. So
she's filed for double jeopardy a couple times now.
She has, and she's went went to their court of appeals, to their district court, and that's all been denied because they interviewed jurors and they said basically we were going to acquit Ms. Reed on 2 of the most serious counts, but we didn't have a chance because the judge declared, and it's the same judge in the second trial, a mistrial precipitously. But in the interim, she gave a interview to Vanity Fair. Prosecutors do, and you tell clients this, and they will not listen. They will get your interview, listen to your interview, and use it against you. So what they did was ask for the raw footage and notes of the interview. That has now been evidence in the second trial. I've never seen this development before. A juror from the first trial is now part of the defense team and a lawyer on the retrial for the defense.
Yeah, and that's something. Yeah, like you said, I've never heard of anything like this. So how does that happen?
Well, it happens. Because the juror said, "I want to be part of the defense team," and they hired him. And you know, who knows more about the case than somebody that was a juror?
Room, sure.
But well, actually, not in the room. This person heard the entire thing. It was an alternate juror. So here's the question that's captivated the country, and the jury is out as we speak, Bo. And the issue is, was an intoxicated Karen Reed, did she intentionally, now she's charged with second-degree murder, that's a knowing killing of another, did she intentionally run over her boyfriend in the snow-covered driveway, or was her boyfriend beaten, killed, and the crime scene staged by fellow law enforcement officers and covered up by Trooper Proctor?
Isn't there also a damaged tail light in all of this?
Well, there's everything about the Karen Reed case isn't simple because the defense says, our experts say there was a damaged tail light that's consistent with that's not consistent with striking a human. The prosecution, conversely, says that it was. The defense is saying that they covered up particles of the headlight and plastic that was at the scene. So, that's up for debate for this jury.
Does this come into play as well at all? Because there's been several people that have come forward and said the two were not necessarily getting along.
Well,
they've been on, the relationship was a little rocky at this point.
But motive is something we all talk about, but it's really not an element of a crime. But the other thing that's fascinating about this case, the judge just in the last few days changed her juror questionnaire because one of the actual lesser included offenses did not have a place for them to indicate not guilty, which was, beyond bizarre.
Had there been some issues with that in the first trial? They had asked and said, we're confused about how to fill this out.
And so here's what Karen Reed is charged with: second-degree killing, which is a knowing, intentional killing of another. And she's also charged with manslaughter, vehicular manslaughter by intoxication. In Massachusetts, it's called, instead of DUI, OUI, operating under the influence. And that's become kind of a hot spot in this trial because yesterday the jurors wanted to know if they voted not guilty for the vehicular manslaughter by intoxication and voted guilty for OUI, would that necessarily result in that case that being dismissed, or would it? What would the legal import be? And the judge said that she could not answer a theoretical question. So a lot is going on, but after another trial, the same judge, many of the same attorneys, it looks like we're in the same position that we were in trial one, and that is a jury that's struggling to reach a verdict.
And we're going to talk about that coming up here after the break. We're going to talk more about the jury. You alluded to a question. They've been asking a lot of questions of the judge. What could that possibly mean as well? We'll take a look at that and discuss it when we come back, so stay with us. And welcome back. Bo Williams again in for Lori Tucker. We're talking with Greg Isaacs about the Karen Reed second trial. We're also touching on the first trial as well, which ended in a mistrial. We want to focus now on the jury. A lot of questions coming to the judge as of late. Before we jump into that, though, we do have a story for you that kind of recaps and get us up to date on where things stand as concerning that topic. So take a look.
Even with no verdict here at the courthouse today, it was still an eventful day, from several questions to a change in the verdict slip. Another day of deliberations in the Karen Reed retrial. Reed is accused of hitting boyfriend John O'Keefe with her car and leaving him to die, but her lawyers say she's the victim of a cover-up. Today, the jury submitted 4 questions, including, if we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges? For this question, the judge did not call the jury back in person to answer. Instead, she sent a note back saying this is a theoretical question, one she can't answer by law.
We're going to end up in the exact same position that we were in last year.
There are other steps that can be taken to perhaps prevent that.
That was the last question of the day. Before noontime, the jury sent in 3 others, which they did receive answers to.
What is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The second, are video clips of Karen's interviews evidence? How can we consider them? And the third, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge?
The judge told the jury it's up to them to decide the time frame. And yes, the video clips are evidence. And finally, the judge moved forward with amending the verdict slip in hopes to make it easier for the jury to understand, going through it with them when they returned in person.
It's a little bit easier for you to follow. And for purposes of going through this, we'll go through it together. And I've got a copy for each one of you, okay?
The defendant's supporters are also expected to be back here tomorrow, ultimately looking for a conclusion to this case. The jury will be back here to deliberate in the morning. Reporting in Dedham, I'm Sheena Loshudo, 12 News.
And again, so the jury, as we mentioned already, still deliberating right now, still coming back with the questions. You've heard the 4 questions there. So, Greg, I'm going to let you kind of walk through here. I know you kind of want to touch on each of them. You heard what the judge had to say. So let's get your thoughts as we kind of break this down now.
You know, when you are a defense lawyer or a prosecutor and a client, or you're a victim, as you're waiting for the jury, they're going to do 1 or 2, 3 things. Right. They're going to find a verdict of guilty. The second thing they can do is find a verdict of not guilty. The third thing they can do is what they did in the first trial, and that's they could find no verdict whatsoever. The judge could declare a mistrial. But when you have a question, then it's puzzling, it's intriguing, but it's frustrating because then you have to think of the best legal response, but you're trying to put yourself in that jury room, right. And you're trying to say, what does this mean? And you're trying to read behind the lines of the question and go, and it typically goes like this. That's very good. That question means that they're blah, 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 blah. Right. They're listening to what we're saying. Or that's not a good sign at all. Right. And it typically turns out to be something different and something whatever. So the defense now, you're looking at these questions, but let's look at one of the first questions. Okay. And it's pivotal for 2 reasons. What time was the OUI? Right. OUI, DUI, basically operating the vehicle under the influence. Incredibly important because that's an element of manslaughter by intoxication. It's important because the question could also mean that they were going to find that she was intoxicated. Remember, they found not only there was the tail light was broken, right. but a cocktail glass at the scene in the driveway. But they could just find her guilty of DUI and say there's no causation, there's no proof that she ever struck her boyfriend. But so that's really important, and there's a wide span of time, and that's what the juror's question was. Was she drunk at the time of the event, or when she was arrested 4 or 5 hours later?
Yeah, it sounds like they're trying to piece together a timeline here, a more clearer timeline.
If she went home and she was drinking, then that toxicology report is not an indicia of her blood alcohol at the time she was operating the vehicle. True. And that's what the defense's theory is. So again, you're sitting there driving yourself crazy. Do they want to know the timeline because they think, well, if she drank afterward, we're not buying what the prosecutor's selling? Yeah. Or, you know, so that's the first question that can be very significant for the manslaughter or whether she's guilty of OUI.
You touched on the video clips earlier, but again, it was an interesting question. If some of this can come back around.
Well, and think about this. You know, it goes back to Lewis Carroll, Alice in Wonderland, when she was talking to the Mad Hatter and said, kind sir, I can't understand a word you're saying. And he says, well, Alice, it's Jabberwocky. Everyone speaks Jabberwocky. So the question to me is, if you're giving an interview with Vanity Fair, you embellish, you're not under oath, does your words rise to the level of an admission or a narrative that can be used against you? And according to this judge, it does.
Right.
So, you know, one thing that's very important, let me give it some East Tennessee context. You know, Bo, you see those big fish on the wall, the big bass?
Sure.
Have you ever seen one with his mouth closed?
No.
No. When you make statements and you talk, bad things happen in criminal cases. So, you know, that's something that she made a calculated decision, and I think it's come back to potentially bite her. Third thing, a lot of I heard this from a judge, won't mention the judge's name, pundits on Court TV, when I was helping cover the first trial. The judge, to me, is not doing a good job. Jury, and the jury questionnaire is a good example. She has now, quote, fixed it. Now think about this, real time in a murder trial,
right.
And you've already done it once and it was messed up. The lawyers are screaming, you can hear them in the background, we're back where we started from,
right.
Same flawed jury verdict form. And the judge goes, well, I made it easier, and let's read it all together after she read it the first time. So I think what you see, and it's really kind of amazing, the judges go back to chambers and they watch the TV coverage and whatever, and I think she realized she was looking like someone that was non-judicial, so she decided to reverse course. So that question, I think, answered itself.
Okay.
The other question, again, is kind of a foreshadowing.
Right.
If we find not guilty on 2, can't decide on 1, does that mean there's a hung jury on everything, et cetera?
That gives you a little more insight on what's going on.
If I'm the defense lawyer now, that's got my attention.
Right.
Okay. I am now, the last question, I'm feeling good about where I am in these prolonged jury deliberations. The judge gave what I think is the correct answer. I can't answer a theoretical question.
Right.
Go back and deliberate. But, you know, Bo, as Yogi Berra said, it's deja vu again. Yeah, all over again. So, you know, another trial, and it's really amazing with a different jury that they're, you know, virtually in the same place they were after the same trial.
Yeah, really haven't. It seems like they're, yeah, exactly. It's a duplicate. I do want to ask you just something, though. When you see something like this, and you see a jury coming back with a lot of questions, and not focusing on what they're saying here, but really focusing on just in general, does it usually play out for one side or the other when a jury has a lot of questions?
Well, again, you want to try to read the jurors' minds, and you want to use it as a gauge on how you're doing. And again, more often than not, you know, what you think the jury means by those questions may or may not be. But it depends on what you want from a jury. Do you want a jury that is picking everything apart? Do you want a jury that is overly inquisitive? Or do you want someone that's going to be persuaded and listen to your arguments as you have made them during the trial?
I do want to interrupt you there real quick. We're hearing that a verdict has come in on this, that a verdict has been reached. It hasn't been what are we looking at? Oh, so they've handed it in and they retracted it. So here's another twist for you.
So literally, as we're here, we're at, here live on Ask Isaacs. The jury is on the precipice of a verdict, and what we'll try to do, if we can get our producers, if there is, please stop us and let us announce that verdict live on the air. But this is the point, Bo, where you're in your office,
right,
or you're down in the coffee shop at the courthouse, and they say you get a call on your cell phone. Everyone get to the courtroom, and that's what they're doing right now in Massachusetts. So everybody is gathering, And we're going to know in just a few minutes.
Have you seen that there where they've come in and they go, here you go. Oh, hang on a second.
Oh, it's as dramatic.
Is that more?
It's as dramatic because you put your heart and your soul into this defense. You're looking at your client, and they're going to either walk out of there with jubilation, or they're going to be handcuffed, and they're going to be put in a cell for a period of years. It is a life-changing decision when someone announces a verdict in a homicide case, and literally everybody in the facial expressions. And here's what you're looking for.
Okay.
When that jury comes
back in, yeah,
you want to know whether they're making eye contact with you. Good sign always.
Yeah.
Or if they look away,
not good.
Not good. So those lawyers, people are going to be sitting at counsel table, and they're going to be waiting, and they're going to be reading those jury's faces, and But now, it's unclear as whether the verdict they took the verdict back. Okay.
That's what they're telling us. Yeah, that they retracted it. So I tell you what, let's take our second quick break here, and then we're going to come back. And if something happens here, we'll let you know. But we'll take a quick break, and we'll be right back after this. All right, welcome back. Bo Williams with Greg Isaacs. We are still awaiting the verdict in the Karen Reed trial. Apparently, the way we understand this, right before we went to the break, is that a verdict was handed in, and then it was basically taken back. And we were talking about this in the break. There's been a lot of different things that have happened in this trial, things that we haven't seen before, heard about. We talked about the former juror who's now part of the defense team from the first trial. This is also something I would have to think you don't see a lot. I mean, do you? Looking at your face, I'm taking it. It's not something you hear a whole lot about.
You do not. And see, what we're getting is media reports of people that are watching this happen in real time. So what I'm hoping is that this is a clerical error where something was not signed, or they forgot to fill out the verdict form completely. But if it's one where they say, "Oops," before you read it, we've changed our mind, which I've never experienced or heard of. This could be
Well, here's the latest. What it says up there. It says the judge said the jury had handed the court officer a verdict slip that is now sealed. Quote, "We do not have a verdict because, as we all know, there is no verdict until it is announced and recorded in open court." That, according to the judge. The judge also said that she's going to keep everybody in court now for the remainder of the day. So it sounds like we're pretty close, that whatever's going on, they're going to get this ironed out, and they're going to hopefully resolve all of this.
Well, depending on which side prevails with this verdict, it's under seal right now. That means it's part of the record in this judicial proceeding, but it's not a public record.
Right.
So, but the first thing that's going to happen if there is an adverse verdict, the defense is going to move to unseal that, and they're going to appeal what that jury returned. So the question's going to be, and Bo, I think it's legally fascinating. You know, Judge Cannon, who herself has problems with the jury verdict form, has said that we don't have a verdict until it's announced and recorded in open court. Yes, but the jury, if the jury returns a verdict, they signed the verdict form, I think that's going to be a compelling argument for double jeopardy if it is favorable to the defense.
Well, if you take a look at what we pulled up here, it says that the judge said in open court today, the jury knocked on a court officer's door to say they had reached a verdict. Shortly thereafter, the jury returned to say they did not have a verdict.
You know, this.
So is that someone jumping the gun, running down the hallway and saying, "Hey, we got something," and someone said, "Oh, hang on a second."
Well, not to use a cliche, but I think we may have a runaway jury, Bo. I mean, that's really, for lack of a better legal term, very bizarre. If I were the lawyers, I would ask for a in-chambers hearing, and if I was the defense, I would tell my client, I would ask my client, please give me permission to move for an immediate mistrial. I would ask that, the jury is excused, they're in there deliberating. I would ask that they stop deliberating. For the record, now I hope these lawyers are savvy enough to do it, I would move for a mistrial. I would make sure that sealed verdict form is part of the record, and I would preserve that right now. And then that's going to create chaos.
Yeah.
And sometimes when you're a defense lawyer, what you want, you know, everybody thinks you want smooth and you want persuasion. Sometimes chaos is your best friend. But think about this. the jury, after deliberating 4 days, filled out a form. They knock on the door. They bring the bailiff in, and then say, "Oops, I want it back."
Right.
Remarkable.
Yeah.
So those lawyers, if I would get up out of my chair, and I would move for a mistrial immediately.
So again, just kind of real quick, walk us through then on the grounds where you say, okay, I want a mistrial on this. Where are you pulling that from?
Because there's been a verdict, and if they're not going to take the verdict,
right?
You can't. I mean, it was handed to the court, the judge. So then what? At what point do you say? I mean, if the judge had announced the magic words, the verdict is blank, and then they all stood up and said, "No, that's really not what we meant." Right. I mean, this is. Or
what in the case in this one line where it says they went to the officer's door and said, "Hey, we've got a verdict," and then a few moments later, we don't know if they actually handed it to him or if they just went back and said, "Oh, well, hang on a second." Maybe
but we do know this. It says the jury handed the court officer a verdict slip that is now sealed. So if it's a favorable verdict to the defense, the argument is going to be made, and it's a compelling argument. That is a verdict. And the judge had a duty to read that verdict, but this runaway train needs to stop.
Yeah.
And they need to get control. The judge needs to get control of this jury. The defense needs to ask for a mistrial. But, Bo, this case that was bizarre from its inception.
Are you surprised that it has come to this after everything else has played out in this thing?
Some things are, it's hard to be surprised in a high-profile criminal defense case, but am I surprised? I'm surprised and I'm shocked because I've never heard of a jury handing this to it. And that's a very formal, because no one's allowed to go in a jury room. You typically have bailiffs that are assigned to be the chaperone or protect the jury from tampering. And when they knock on that door and they hand someone this jury form that has been signed and a verdict indicated, that's a very secular I mean, that's the foundation of our system of justice. So you hand that to the court officer, he goes in, it's over. It's just a matter of getting everybody in their chairs for the judge to read the verdict. So the only thing I could think it would be akin to is when you have a wedding and someone says, is there anyone here that
and someone says something?
I want to object, and someone stands up and says, I do. And, it only happens in the movies. But this is legally bizarre. It's fascinating. It's happening in real time. And someone needs to get control of this jury and that verdict.
What are the chances, do you think? And I know we're not there, but the chances of this becoming back-to-back mistrials?
I think it's good. I mean, now the appeal, the issue of the jury making a decision.
Now, what's this now? Oh, looks like we're trying to look in on something here. See if we get a live picture. Possibly, is that what you're trying to get there, Jeff, of the... Here we go. Looks like... we can see it on our screen here. See the judge. We can't hear what's being said, but there we go.
2282 CR 117001, murder in the second degree. What say you? Is the defendant at the bar guilty or not guilty?
Not guilty.
So say you, Mr. Foreman? So say you? No. Do you agree?
Yes.
Do all of you agree?
Yes.
Thank you. 002. What say you? Is the defendant at the bar not guilty or guilty?
Not guilty.
Of?
Is not guilty or guilty of that charge or any lesser included charge? Thank you. Specifically, number 5, operating under the influence of liquor by operating a motor vehicle with a blood alcohol level of 0.08 or greater. Correct?
Yes.
So say you, Mr. Foreman?
Guilty.
So say you all?
Yes.
003. What say you? Is the defendant at the bar leaving the scene after accident resulting in death? Is the defendant not guilty or guilty?
Not guilty.
So say you, Mr. Foreman?
Yes.
So say you all?
Yes.
Jurors, hearken your verdict as the court records that you upon your oath say the defendant on 001 is not guilty, on 002 is guilty of operating under the influence of liquor, and 003 not guilty. Thank you.
All right, jurors, everybody please be seated. Jurors, we thank you for your service. We're going to send you back to services complete. I'd like to.
All right, so there you heard it. They came down, they've read it. You can hear, you heard the not guilty, the not guilties, but also the guilty as far as the operating of the under the influence. But other than that, not guilty. And you heard the crowd who had assembled outside, and you heard the screams. I'm assuming that's what we were hearing there after everything was read as well.
We did, and you guys did an excellent job. Thanks, Jeff, and Hope for bringing that in. But, it appears that we talked about, we were trying to speculate what the question may have been about the OUI, when it happened, how it happened. And it looks like, and one, if you're Karen Reed, what a result.
Right.
Not guilty of homicide, not guilty of the other, but it looks like they settled on a potentially compromised verdict, a misdemeanor driving under the influence charge. So what a dramatic turn of events. What a dramatic way to read a verdict. And
I was going to say, just the delivery of it there as well was.
But you can see it as we're watching this on a split screen. The just adulation and the emotion and the relief. And there's nothing like the feeling when a client
be aware that if the records regarding
when you get a not guilty verdict, but wow, even it almost if they wanted to snatch victory from the jaws of victory when they tried to take the verdict form back.
Right.
But all things.
What a crazy final 2 or 3 minutes here, huh?
Yeah, all things involving Karen Reed
Right.
are legally atypical and bizarre, and it'll be interesting to see how it shakes out. What was the issue with the verdict form being tendered?
There's still a lot of questions about how that played out and what exactly happened behind the scenes there.
But what a trial, and again, there were two very separate, distinct theories. Did Karen Reed, because she was arguing with her boyfriend and intoxicated, knowingly and intentionally kill him by running him over with her vehicle? Or second, was he beaten, taken outside, and staged by a crime scene? But then again, maybe the jury is unsure over what theory.
Right.
Is it because at the end of the day, the state has the burden. Karen Reed had no burden, but the state has to prove each and every element, Bo, beyond a reasonable doubt. And I think when you factor in the expert testimony, when you factor in Trooper Proctor being friends with the people in there and being summarily dismissed for misconduct, I think that all weighs in when the scales of justice are being kind of weighed back there in the jury room. They can't carry that heavy burden beyond a reasonable doubt.
Well, this definitely kind of went along with the question that we talked about earlier when they came back and said, what does this mean if we've got, two areas here that we don't have a verdict and one that we do? Let's see what else is coming in here. Sentence, 1 year probation. No? Is that what it is? Yeah. Like every other. So there you go. So 1 year probation. All right. So that's it. Karen Reed, if you're just tuning in, not guilty of second-degree murder and the death of her police officer boyfriend. We'll talk more about this coming up tonight at 5:30 on WATE. And again, this will be something that will be talked about, I'm sure, for quite some time, just the way this whole thing played out. But Greg, what an eventful last 5 or 6 minutes here as we started getting word that there was a verdict and how all this played out, and now it's over.
Fascinating. Now there's closure. She's guilty and on probation for a misdemeanor offense of OUI. But what a trial. What two really divergent theories was presented in that courtroom. And the good thing, whether you're Karen Reed, you're a victim, you're a participant, there is now closure to the Karen Reed case.
All right. And on that, we're going to wrap things up. Thanks so much for watching. We'll see you again next week.